Good morning, everyone. Let's make a start because we have a ruthless schedule to stick to. And I'm a university professor, so I'm used to killing good conversations just as they begin first thing in the morning. So welcome to the panel on generative AI and copyright. It's a pleasure to introduce the panel to you this morning. They have real expertise, and I'm looking forward to hearing what they have to share with us. Isabelle Doran is the CEO of the Association of Photographers. And she's going to be representing them in generative AI debates at the moment, where images are used as training data. She has extensive experience of photography licensing, including working for a predecessor of Getty Images at one point of time. And she is also familiar with copyright policy since she's a director of the British Copyright Council. Full biographies are in the pack, but I thought the most relevant bits is something I should foreground here. We next have Dr. Andreas Guadamuz, who is a reader in law at the University of Sussex. Andreas is someone who has been working at the interface of technology and copyright for a while. Open source software, Bitcoin, sort of electronic money, but increasingly from 2017 onwards on AI as it's starting to affect copyright. So in 2017, he authored Whether Androids Dream of Electric Copyright, which will instantly win over all the Blade Runner fans in the room. And he's continued working on AI, and in particular, when machines create, what does it do for IP law? And that's been a central question he's been exploring. And Dr. Chris Mammen, I'd love to welcome back to Oxford Dr. Chris Mammen. The doctor in Chris's name is because he did his doctorate at Oxford in legal theory. He's presently the managing partner of Womble, Dickinson in the San Francisco office. And Chris he has extensive experience of working in the high technology sector, advising parties, including in very complex litigation. So this is from startups to established tech companies. Chris brings a depth of expertise to that. Chris was also at Oxford last year on sabbatical, and this shows you something about the way he enjoys life. He chose to spend his sabbatical at Oxford, putting a team of interdisciplinary researchers together, psychologists, design specialists, computer science. They even allowed a few lawyers in, and we worked on why creativity matters. So the process of creativity in terms of how generative AI is challenging that, the very human, relational, bouncing and riffing off process of creativity, and what we learned from the process is what we concluded was important at the end of that study. So it's an excellent panel, and I'd love to thank our host, SoxGen AI, for putting us together, and we're looking forward to going. Just a bit of a preface. The context around the panel is, as many of you know, the UK is at a weather vane moment where it's swaying between different directions and trying to choose a path forward, supporting its creative sectors, because the UK punches above its weight when it comes to film and culture and music and photography, and also its developing software and generative AI sector, because many of the most promising companies, the trend seems to be they tend to flee to other jurisdictions, and DeepMind is an example of that, where they feel copyright law is more favorable. So how do you balance these two things out? Sustain creativity while continuing to support the development of technology. So that's what our panel is going to be digging into this morning. So I'd like to begin by asking our panel, and the panel will be speaking on all questions. So it's going to be a flow. Technology has stymied us. Our clicker doesn't have a way of plugging in. So we're going to have to do this old school. I'm going to have to wave my hand around when we need the next slide or put my thumb up, and Ed at the back is going to magically make sure the next slide pops up. So I'll begin by asking why we're talking about this copyright as it interfaces with generative AI at this moment. And one of the reasons why it matters is because it affects people's livelihoods and it affects the creative sectors. It also maybe affects how we value creativity. So I'm going to ask our panel to share their thoughts on why they think this is an important moment to be thinking about this and how generative AI affects creative professions. Isabelle, could we begin with you, please?
Yes, of course. And I'm delighted to be here, and obviously delighted to see people in the room, prepared to listen to our conversation. So that's fantastic. So yes, in terms of slides, what I wanted to try and do was to give an overview from our perspective. So as I've been introduced, not only do I sit on the British Copyright Council Board, but I'm also a vice chair of the Creators' Rights Alliance. So in that respect, I have a very good measure and very good understanding of the impact of creators in that respect. So if we can put the first slide up, that would be great. And then I can stop turning around and looking behind me.
Next slide, please.
Oh, here we go. So again, just in terms of the context, from our perspective, obviously data scraping, in some respects, I feel as if there's been a wrong interpretation of what many of us know as public domain. So public domain is usually works that are either out of copyright or the person has relinquished their rights in that respect and handed them over to the public. Whereas publicly available seems to be a wide interpretation from some within the big tech echelon. And so in that respect, it seems as if the premise for a lot of this large AI data scraping has happened as a result of that. Part of the problem is, of course, as many of you will be aware, is that from the creative industries and the creators' perspective, this has been done without rights holders' permission. And of course, in an ordinary sort of business sense, if you were to, approach somebody to say, I want to use your raw materials to make X, Y, or Z, you would seek permission and you would exchange, some kind of monetary value in that respect. And that hasn't happened in this case. So of course, the no permission or transparency on training is critical to, a more ethical and fair and responsible way of progressing forwards with generative AI in that respect. So transparency being particularly key, because without transparency about what's going into the machine, we don't necessarily know how to value it and how to find that compromise between the two sides. And one of the things that have come up quite often is about opt-outs as a mechanism, which again has featured quite heavily in EU copyright law, the DSM, I should say. And opt-outs from the creator's perspective, again, is a real challenge because we have very little control of what happens downstream. And we all know about, I suppose, the pervasiveness online of materials shared in that respect. So content shared, it's prolific. So for us to be able to control once something is put online, where it's disseminated to and how it's then scraped is a real challenge and not something that can easily be dismissed. But hopefully, next slide. So that gives some kind of context on the one hand. Now a few stats, which I quite like to provide. I've been, a policy person for probably about 7-8 years now. And of course, dealing with government, you need to be able to back up what you say. So for one context, for example, because within the creative industries, we have different sectors, the photography sector is sort of bunched up between TV, film, and radio. So it's actually quite hard to be able to know exactly how many photographers are impacted, particularly in the UK. So this is unofficial, but I was able to get it through my MP, which if you ever need any information, they're very good at doing that. But there's about 50,000 professional photographers in the UK, in England and Wales specifically, which is rather a lot, actually, when you consider it. Now, the average turnover when we did a survey with our members was approximately 105,000 a year, which is, on average, potentially much higher than most, but that's because ours are professional commercial photographers who work in that vein. So everything you see visually around you, whether that's a billboard, whether that's a huge ad campaign, our photographers are generally behind that. But when we also did this survey, what we were quite surprised to find, and this was back in February, was that already 58% of our members had lost work to generative AI. So this is conscious decisions by their commissioners, by the people who would be hiring them, that actually they would revert to generative AI. And we know this why? Because they've asked. Our photographers are pretty, they have good relationships, but if somebody says, actually, we think it's going to be more cost effective for us to do this, that's what they've come back with, and that's that result there. But it also equates to an average loss of about 43 million so far, and that's just one small section, and we represent about 3,000 photographer members. So you can extrapolate that larger. There's probably potentially quite a lot of work and an average loss of that value transfer. Two other critical things I wanted to share with you was about how many of our photographers wanted to see transparency from AI companies. It was pretty high, 98.5%. I mean, it's not 100%, and we know with scientists, they never like 100%, so, and I am married to one, so I'm well aware of that. And then for to be compensated is a critical thing again. So this was again very high. It was 97.4%, and this is for past infringement. So effectively, the request would be, can we get some compensation before we can then start negotiating future licenses and future progress in that respect?
Yes. First, I'd just like to say how delighted I am and how apt it is that the creative industries are represented here by Isabelle today. Photography has been at the center of many of debates over copyright for about 150 years. One of the earliest cases involving copyrightability of photography involved some lithographs or trading cards of Oscar Wilde, and some of the comments in that early decision have continued to guide us today in terms of how we think about these issues in relation to generative AI. And the slide up on the screen is a somewhat different point. One of these images is of course an image of a Rembrandt painting, and the other is a 2016 image of the outcome of a project called Next Rembrandt that was trained on Rembrandt. And the question is, and one of the framing questions here is the artifact created by Next Rembrandt, that image, just as good as human-created art, worthy of copyright protection? And to what extent is the quality of that then really derived from the fact that the training data was all Rembrandt data? And this really encapsulates several of the key themes that we're going to be talking about. One is the powerful economic forces on all sides of the debate, the question of the extent to which these technologies unleash creativity or simply repackage others' creativity, and other themes like that. But I'll pause there so we can continue on.
Yeah, thanks. Thanks again for the invitation. Delighted to be here. It feels a little bit strange because I'm just an academic writing about this stuff for many years, and I always joke that it feels like I'm one of those people who was following a band when it wasn't popular, and at some point it became very popular, and then all of a sudden oh my God, everyone likes the same thing that I like, artificial intelligence, for many years. So what I find fascinating about the subject from a legal perspective, from a copyright perspective, it's that it has become one of the hottest legal subjects in the world, and it's fascinating as a researcher. I get questions all the time. Now, I had a class recently, and I was trying to convince my students that I am cool, or probably every professor or lecturer has that problem. And I was telling them, okay, actually, I can claim that my subject is the top legal subject in the world, and I was telling them about all of the lawsuits and everything. And they actually sort of looked convinced that AI was important because of the settlement, the 1.5 billion settlement on Anthropic. So it was telling them, well, look, there is, in paper, this is a hot legal subject. The lawyers got 300 million as an award, and the authors get $3,000. Well, that's a different question. But what's important here is, besides all the jokes, despite all of the claims that the AI bubble is going to burst and all of the companies are going to go out of business, I strongly believe that AI is here to stay. And all of the companies that are getting sued could go out of business tomorrow, and there would still be AI revolution. Now, how that goes forward is precisely the questions, the legal questions that we are asking. And I believe that we are right square in the middle of all of these questions being answered by policy, by case law, 55 cases that we're going to potentially talk about. And it's very important because of all the creative elements that we're seeing, that we're going to hear about, but also all of these companies that are developing AI tools, not all are evil or often paid as evil in the press. They want certainty. They want legal certainty in these legal questions. What happens with the copyright of the things that we create, that our users create? And most importantly, are we going to get sued out of existence? So these are very important legal questions that we need answers to, because all of these markets are going to emerge in technologies that we probably haven't even thought about. So that is the first thing. The other is that also I want to remind that creativity itself, creators are starting to look at AI and using tools. Just a couple of days ago, the very famous Japanese game developer Hideo Kojima, Metal Gear Solid fame, he just came up and said a lot of people are using AI for creative processes, and we are using them. He was saying, I'm using it as a friend. I do the creative process, and the AI does all of the hard work or all of the things that I don't want to do myself. So those are very interesting things to think about. What happens if they use AI with those creations, and what's going to happen? So that is sort of setting the frame, the problem.
That's a fantastic overview about what the stakes are and why it matters. And I think I'm going to pick up on something Andreas said, which is why this area is so important. Why is copyright suddenly pushed to the foreground? It's because the training data is where much of it starts, and the volume of data and the quality of that data are really important, as people in the room know. And copyright seems to regulate how that's accessed. And copyright has when it's a situation where it's just a very large scale need for access, copyright often steps in with defenses. And the defenses are structured around two principles. Do you need permission? And do you have to pay to use it? And sometimes you don't need permission, but you have to pay. Sometimes you don't need permission and you don't have to pay. And we're trying to figure out what the best approach is for accessing training data. So the EU and the UK are considering, have gone down an approach with a specific text and data mining exception, whereas the US is using its flexible fair use test to try and see if it's fair to access the training data. And the problem sitting behind it is the sheer number of rights holders and the difficulty with transacting with each of them individually. So looking at whether some kind of collective solution can be found, and that's sitting behind this. So if I could get our panel to reflect a little on the UK and EU approach to a specific narrow text and data mining exception, and the US's more flexible fair use approach. Isabelle, would you?
Thank you. So maybe slightly controversially, I'm not necessarily sure, and I think there are others who have written about and feel the same, whether the text and data mining exception is actually applicable to commercial use. So, for example, in the UK, we have a text and data mining exception, which is for research purposes. And obviously, we're in, fantastic, fantastic city for universities, not alone just one, obviously, but in that respect, the text and data mining exception for research purposes exists. Where it's then applied to the EU, of course, we have Article 3, and I'm not sure how many of you in the room are aware of the Copyright DSM directive in that respect. But there are two key articles that are reflective of text and data mining. Article 3 is, again, for research purposes, which is very clear, but Article 4 is where there has been, again, an interpretation, and probably quite a broad interpretation. I think sorry, I'll be closer to the mic, broader interpretation than, I suppose in that respect we would feel. So really, what we're looking at is, I think from Articles 3 and 4, is that it's the analytical use is really at the heart of what everybody's trying to get. Whereas with Article 4, it seems as if that has gone beyond potentially generative AI and data scraping and the training of those works goes slightly beyond to a more expressive reproduction. So in some respects, I'd say that Article 4 was intended for the analysis of semantic information, not the syntax, where you're extracting functions for Gen AI training and the models that come about. Also, importantly, with the text and data mining exception, with the training of generative AI, ordinarily it wouldn't necessarily pass the 3-step test. Now, this is applied to the Berne Convention, which a lot of different countries have signed up to. Again, I'm not sure how many of you are familiar in the room with that, but essentially the 3-step test applies in several different ways, but essentially importantly, it's about not competing in the same marketplace, and importantly, it's not meant to substitute those works in the marketplace. So again, looking at it from a market perspective, when we were looking at the statistics that I provided you with, it very much feels as if that representation is happening, that there is competition in the marketplace that's happening as a result of the, for example, the visual generative AI models. And so, of course, that is, I think, really important to distinguish in that regard. I know as part of my response, I'm supposed to mention about fair dealing and fair use, but I don't know if you want that to come up. Absolutely. Brilliant. Well,
Isabelle made a very important point here. So if you remember the Google Books litigation from a while ago, this is in relation to her Article 4 point, which I think is an important one. There are ways of doing text and data mining where you try and pull out almost technical metadata from works. The number of times a word features, when a word first starts appearing, and I think Isabelle's saying that kind of analysis is fine under Article 4. But the moment you start reproducing books or photographs or text, then you're sort of sliding out of the Article 4 exception, because you're using it to create competing substitute works rather than analyzing works for patterns, which is what Article 4 was originally for. Chris?
Sure. So if we could go to the next slide. We've got an extra slide in here. So Andres mentioned the over 50 lawsuits pending just in the United States. This is why copyright is top of mind and cool and interesting to our students and our younger lawyers, is because there's so much going on in the space right now. This graphic is from a website called ChatGPT is Eating the World, so you can feel free to go check it out and check out the latest. So the fair use factors under U.S. copyright law are what we apply by way of analog to the text and data mining type analysis on this side of the Atlantic. And there are 4 factors. There's the nature of the use. There's the type of information that is protected under the work. Is it factual or highly creative? There's the extent and substantiality of the use. How much of it's being copied? Is it just a snippet, or is it the whole thing? And then the 4th factor, which is often considered the most important factor in courts analysis, is the financial impact of the use on the rights holder. And if we can go to the next slide, we have 2 rulings that came out this summer, about a week apart, from 2 judges who sit very close to each other in Northern California. And they reached, although the headline rulings were the same, that the use of copyrighted material as training data is fair use, that it's permissible to train generative AI platforms. They actually analyzed it very differently. The first 2 factors, their analysis was more or less the same. The 3rd factor, the extent and substantiality of the use, it is interesting in that it illustrates just how hard it is to apply these factors in this context without more guidance. One judge held that because any particular output from a generative AI black box contains only an infinitesimally small influence of any particular work, then the substantiality factor is very small and therefore favors the AI platform. The other judge said, well, actually what matters is how much of it is copied and imported on the input side, and clearly the whole work is imported on the input side, but in the context of what generative AI training is about, that's still okay. So they couldn't even agree on whether we were talking about this factor applying at the input or the output. The fourth factor is where I think we're going to see the most action in all the other cases to be decided in that map that I showed you. The first judge held, look, there's no right in copyright to be free of competition. And unless there's exact copying, sort of memorization across to the outputs, the copyright holders have nothing to talk about here. And the other judge held that actually there's a theory of sort of aggregate economic impact, the kinds of things that Isabelle was talking about, how AI is displacing the ability of human photographers to earn their livelihoods, and that some sort of theory around that is a legitimate way to analyze this fourth fair use factor. However, he held the parties in the case before him had not presented that evidence, and so while he was sympathetic to that idea, he could not rule for the rights holders because they hadn't put in a good case on that. So, that's an invitation to try that further. One further note on the BART's settlement, the $1.5 billion Anthropic settlement, is it actually did not pertain to the use of copyrighted material to train the generative AI. In that case, there was also a set of allegations that at the same time there had been a pirate library or a reference library made alongside the training, and that downloading books from LibGen and PyLiMai and Pirate Library Mirror and other pirate sources, and then keeping copies of those was actually the non-fair use infringement that led to the settlement. So the $3,000 per book benchmark is headline grabbing. It remains to be seen whether that becomes a benchmark going forward for any generative AI training settlements.
Actually, if I could come in just on that as well, because of course you mentioned there are 55 cases. There's a lot of cases and we've still yet to see. And of course, the one thing about US law is that of course it's always done on a case-by-case basis. So what we're really intrigued, well, certainly from my perspective, very intrigued to see is the where Getty Images case, which is the only photography-related copyright case that is both in the UK and in the US. And then, of course, we have the last sort of big cases that have been filed in the summer, which, of course, we have Disney, Universal, and Warner Brothers, and that was against Midjourney, who probably, out of all the visual text-to-image models, is probably the most egregious in terms of, or aggressive in terms of how they've approached the use of copyrighted works. But again, with all law, as we know, in all cases, you just have to watch the space and see what the judges say.
Andres, could I ask you to say either something comparative about the two approaches to defenses or something on Getty Images or both?
Yeah, so first, just quickly, I'm actually on the LibGen data set, but I don't get access to $3,000 because I didn't register my copyright. So there you go. Interestingly, what we're seeing, perhaps, we need to zoom out a little bit. I'm putting my UK hat on. I'm Costa Rican British. I'm very rare Costa Rican British. But what is happening with us is we have a text and data mining exception in the UK, which only applies for research for non-commercial uses. There were a few organizations that were doing some text and data mining and training in research settings. A couple of them were taken down. One that was actually based here in Oxford, which was for video. Now, the difference with this, with the UK, is that because of this fact, only research organizations can conduct training in the UK. Most of the training that is happening, even from UK companies, and that includes Stability AI that is getting sued in the Getty Images case, is taking place outside of the UK. Even UK companies are not doing their training here. So why is that? Because we have very restrictive text and data mining regime. Now, one could argue
GPUs and power, energy and powers. Don't forget those.
There are other reasons for this, of course, but if the government wants to bring some training here, they also have to sort that out because the companies do not want to get sued. And one of the interesting results of the Getty Images case is that the copyright infringement part of the direct copyright infringement part of the lawsuit was dropped by Getty because the training had not been done in the UK. Now, we have to look at what's happening comparatively with other countries. So in the EU, we have the broader text and data mining exception, which we can argue for hours and hours on what are the extent of those exceptions. This is getting litigated in court right now. There was a case in Germany, the Lion case, which is under appeal now. There is a case that should be decided in the next couple of weeks. GEMA Music, the German music organization, sued OpenAI. That is going to be decided. Apparently, it's not going to go OpenAI's way. And then Google are getting sued by a Hungarian company, which I think it's a link farm, but that's beside the point. And this is going to take place at the Court of Justice of the European Union. So we have all of these decisions that are going to tell us the extent of what the application of text and data mining is in the future. Hopefully, we're going to get some certainty because at the moment, nobody knows what's happening. And if they tell you that they know what's happening, they are lying to you. So we need more case law. So sort of from a comparative perspective, and then we have all of the US cases. A lot of the training is taking place in the US because of the uncertainty, but also because of the resources. So there is more resources there, and it's cheaper to conduct it there. And what's happening is that if the UK, and I'm going to be agnostic on this, if the UK wants to be an AI powerhouse, it has to sort this out immediately, whichever way it goes. Because at the moment, the exception that exists is not working for anyone.
I'm going to just quickly sort of one more point to throw in, building on what Chris was talking about the US fair use factors. I think what we're seeing from the early decisions is it's, as Chris emphasized, not blanket permission. It's also quite dependent on how the model works. So it's not just any multimodal large language model or just about free pass. It really depends on what the model is designed to do. And if it's designed to produce competitive works, then it falls out. It falls out of the fair use factors. Mm-hmm. And that's an important learning as well. So we're starting to get into quite specific open spaces for models, even in the US, which is seen as a more permissive system. I might move on in the interest of time to the next topic, unless you want to jump in on the comparative thing quickly.
Just very quickly, just a point of clarification more than anything else, so it won't take very long, is that in the US, just again for context in terms of copyright framework, in the US they have fair use, in the UK we have fair dealing. Mm-hmm. And it's very important to underline that, particularly as, fair dealing is about being fair to the copyright owner. And it's about as acting as fair-minded as a person would be, which includes, for example, licensing for commercial use. So I think it's important just to, as we're in the UK, and it's a UK crowd predominantly, not all, but I think it's important just to underline that.
Thank you. Okay, we're going to change gears now from the input side to the output side of things. And I think one thing I'd like our panel to talk a little bit about is the idea, the notion of memorization, when the output looks a little too much like the training data. So we're starting to look at whether the outputs infringe, and if the outputs infringe, who's responsible? Is it the platform? Is it the user who gives the prompt? And how does that work? So maybe if I could ask Chris to start us off on that.
Sure. So this is an issue that arises in a smaller number of cases. There's been some research out of Cornell University that provides a very compelling side-by-side set of images of what went into the training data and the images that came out, and they look very much like each other. It's also the subject of at least two of the pending lawsuits. One is the US Getty Images case, where throughout the complaint that was filed, there are copies of the images from the Getty Images database and images taken from the defendant, generated through prompt engineering. And then the other lawsuit is the New York Times case, where the compelling evidence attached to the complaint is a red line version of the original published article, and then an output from the AI showing that 90% or more of the output is an exact match. And so the easy answer is, well, of course that looks like copying. What we're starting to see as those cases are litigated, particularly in the New York Times case, is how much prompt engineering and iteration went into producing a result that so faithfully copies the input. And so that is part of the question. As Dev pointed out, the technical details are really going to be extremely important in these various cases. And for now, the accused infringers are the platforms that provided these outputs. It could be an interesting question down the road. I haven't seen it start to emerge yet, whether the users who enter the prompts resulting in the generation of those outputs might be looked to for liability. And you say, gosh, why would anybody go after all the individual consumers? And my glib response would be, well, look what happened in the music file sharing, peer-to-peer file sharing second wave of copyright litigation 15 or 20 years ago, after the platforms had been fully litigated. Then there was another wave of litigation against the individuals. So that may be coming.
Yes. Just a brief aside on that. That didn't work out that well for the music industry. Those lawsuits, I would say, they were suing. I remember they were suing grandmothers and dead people, and obviously there was a meme: "I sued dead people" at some point. But having that aside, the interesting thing with the outputs and memorization is that the memorization is not a legal concept. It was a technical concept created by Nicholas Carlini. So whenever we're looking at whether or not something is infringing an output, is infringing copyright, what we're looking at is whether or not that output resembles substantially something that was in the input. And that is going to be decided on a case-by-case basis. We need to start looking at this. Most of the new cases are going to be asking that question. My own intuition is that the infringer is the person that is making the output, but the tools are getting sued. Midjourney is a good example. Midjourney are getting sued by Disney and other companies. So this is definitely going to be, the next generation is going to be about the outputs specifically. It's very easy to produce an output that produces a character. Just try Pikachu and Mario having a beer. I've done it already, it is very easy. It knows Pikachu, it knows Mario, and it can reproduce them correctly. Now, are there exceptions for this? Maybe parody, maybe pastiche? Those are different questions that are going to get asked.
In the interest of time, I think we're going to zoom to a related question, because Andres was talking about playing around with this. in terms of hybrid human AI work, as people start to use generative AI more and iteratively and produce things, who owns the output works? And I think that's an interesting question, because we're really asking who's doing the heavy intellectual and creative lifting there. And often sometimes it's easy to say it's actually the human being in the driving seat. Sometimes you sort of look at it and say, but it's just a 3-sentence prompt, which then creates a very detailed image. So is that enough for the human being to claim out or copyright in the output? So could I ask the panel to reflect on that, maybe starting with Isabelle?
Of course, and I'm sure it's no surprise which side I'm going to land on in that respect. But I think most importantly, it's for me, the question is, who do we want to incentivize? So, the creative industries in the UK, huge success. A sizable 126, 25 billion, depending on which report you look at. But essentially, it's a significant industry which has successfully reached where it is. And in many respects, AI as a tool has been around for some time. It's not new. I mean, when you look at Photoshop, AI has been part of that for some time. It's the introduction of generative AI, and in that process of creativity, where are we using generative AI in that respect? In many respects, we've been looking at this in some detail, just from the perspective of where the human being is in that process. If they've started with their original idea, their original expression, whatever tool they've used, so whether it's a pen, a paintbrush, a camera, the point is that they've made a lot of creative choices about what they're going to capture in that respect. But they have control of that from the start to the middle to the end. As soon as you introduce generative AI, then it's a question of who has used the program, who has developed the program versus the user at the end. Is it the same person? Therefore, you could potentially say that there is copyright in that process. And I've met many artists who have the genius to be able to design a Gen AI program that they've put in their own materials in and output work using that process. But from the perspective of a process that, a wholly generative AI process like Midjourney or Stable Diffusion, arguably there's quite a distinction between the developer and the end user. And the end user is using a fully processed machine in that respect. And so therefore, the question would then be with the output as to how much of that output is original or not. Arguably, it's not. Actually, the original works are all of the works that have been scraped and go into that machine in the first place. And there's a fantastic visual example, which it might be a good time to show it now.
Sure. Can we just jump to, there's a slide of a leopard. Can we go ahead a few slides, please? One more, please. That's it.
This one. So this is, and again, this is for context, I think, which is really helpful. This picture is taken by a world-renowned photographer who's our president. He's also potentially one of the most scraped photographers in the world because he's been very prolific in his book publications. He has several incredible books. He has a very distinctive style. It's not this particular style in that respect because it's ordinarily a tiger or on a black background. So it's an animal on a black background. And he's actually coming out with a new cat book. If you're a fan of cats, it's literally coming out next week. So, and it's incredible. But he's had to future-proof his book by setting up QR codes and filming in the background to prove that his images are real. But this particular one, he wanted to experiment and just see, well, what happens when he uses Midjourney just to see. And all he did was type in Snow Leopard by Tim Flack, and that's what it output. And what you'll notice is that's an old iteration of Midjourney. Midjourney has moved on since. But the spots on the center, the forehead, are practically identical. And that's all he did. He didn't have to have a whole list of prompts. All he had to do was to put in his name. And in one of the US cases, 16,000 prominent artists were embedded into Midjourney in order for users to be able to mimic their style.
These two photographs in comparison give a whole new meaning to spot the difference, but apologies. But the important point I think Isabelle was making was is AI a tool, or is it a co-author, or even the main author? And therefore, how do you approach it through a copyright lens there? Chris, would you like to?
Sure. If we,
go back a couple?
yeah, 2 slides back, please.
Thank you.
So in the U.S. right now, the Copyright Office's position is that only humans can be authors and inventors, and only human work product is entitled to registration. The gloss on that is that merely typing a prompt into a generative AI tool does not exercise sufficient creative choices and creative control over the outputs. That position was stated in 2023, and there was some room for that to evolve as prompt engineering, of course, continues to evolve with the platforms. But what that means in practical purposes is that there can be hybrid work products. And the example that's up on the screen is a graphic novel that was created by an artist who used Midjourney to create the images, and then she wrote the text, and then she laid out the graphic novel combining the text and the images. She filed a copyright registration for the work as a whole, and then posted on social media that she'd managed to get a copyright registration on an AI-generated work, which caused the Copyright Office to say, hang on, wait a minute. And then after further analysis, the Copyright Office concluded no registration of the images, but yes to registration of the combined work as a whole, and yes to registration of the text. And so this is a very clear illustration of the boundary lines, but it also leads to consideration of, we all have amazing AI in our phones. The images that come out of the tiny cameras in our phones are very much AI enhanced. Does that mean that if we are wanting to register copyrights in that amazing picture that we get of our cat at home, we need to disclaim any portion of that was enhanced by AI? It's got to be an evolving conversation. The image that's up now on the screen is also another illustration. An artist, Jason Allen, used Midjourney to come up with a base image, and then spent something like 600 iterative steps refining that image to come up with the final image, which he then entered in an art competition in Colorado and won. And again, he was asked to disclaim the AI contributions to the final work. He refused to do so, and because he refused to disclaim the AI, he was denied copyright registration.
Okay, just in the interest of time, very briefly, UK law has a provision, section 9, paragraph 3, that allows for computer-generated work. The authorship of that work is going to be the person that made it possible for the work to be created, but that solves only the authorship question, not whether or not this deserves copyright protection. That is, I think that we don't need to change copyright law for this. If there is enough originality that goes into a work, that should be protected, and that can be very, very, very low in UK law. We have very recent case, THJ Systems, very basic graphic user interface was used to make very, very basic graphics, and this was protected under copyright, but it was very, very low level of protection because the creativity the originality that went into this was very low. So I think that we cannot close the door on copyrightability of AI works as long as there is enough intellectual creation that went into the creation of this, and that can be selection, that can be a very, very innovative prompt, but it can be all sorts of different things. I generate lots of images, and I'm always selecting. We cannot do this also for practical reasons. Increasingly, AI works are very difficult to discover whether or not they are AI or not, unless they come with a tag, like Sora videos now come with a tag, which can be removed very easily. So we don't have the resources to pursue absolutely everything that is going to be generated in the world with a copyright police that is going to try to discern whether or not something has been AI generated or not. We'll have to have human presumption until proven otherwise.
Fantastic. The panel has more to say. We discuss things like whether styles should be copyrightable or not, because often what the Gen AI reproduces is a stylistic approach rather than a specific image. We also wanted to talk about licensing models, but I think we'd like to hear questions from you now. We can come back to these two topics. Just ask us as a question. Over to you, please. We welcome questions. There are mics circulating. Yes, one mic.
Hi. So copyright has been an issue since YouTube, right? Copyright was a huge issue on YouTube because it was an exact replicas of copyrighted material. Viacom lawsuit was the big lawsuit. It got settled at the end. Just a disclaimer, I used to work at YouTube. And I'm now an AI filmmaker, so I make AI human combined works. So this is a very deep topic for me. One question that I have in my mind is YouTube solved for this copyright issue by turning it into a monetization opportunity. They took a risk and turned it into an opportunity by creating what they call content ID. And now everybody uses it. The copyright issue is not an issue on YouTube anymore because everybody makes money. The creators make money, platform makes money, copyright owners make money. Can we not imagine a similar world with generative AI, right? So couldn't OpenAI technically build content ID where copyrightable works like Shrek, etc., which is in the Mid-Journey lawsuit, could be very easily identified by the system that's generating it and actually distribute revenue accordingly. And then you take the risk, and again, you turn it into an opportunity. So, but again, I'm like, why is this not already happening is a question. And I think my version of the answer is that it's because they're using copyrighted works to build a platform, because that's what YouTube did as well. And then I expect it's going to come. But then does every platform have to generate a specific content ID? Like we can't have just one. Google needs to do the same thing for VO. You know, Stability, I have to do the same. Is that is that possible?
No, it's a very, very good question. And in that respect, I mean, I'd probably say that leads on to the licensing question that we weren't able to get to. And I think it's about willing partners, I think is fair to say. So the creative industries is used to licensing, is used to that approach in that respect, and either does it through direct licensing, which is what we've seen with lots of newspaper and magazine publishers, and obviously sort of more increasingly book publishers as well. But in terms of collective licensing, we haven't seen much of that yet, and in some respects that probably would apply in that respect, because what we're talking about is, if we're talking about millions and billions of works, I mean, in the Lion 5B dataset, there was 5 billion there were 5 billion images that were used to output synthetic works. It is possible, I think, to be able to do that, through collective licensing in that respect. It is the most well-known mechanism that is global, that you have in different countries, different representative organizations that can apply that. But again, it's about willingness from the other side, shall we say, who we need around the table to have those discussions. One of the interesting points that was raised to me by one of the big tech firms, who will remain nameless, was they were concerned about who held the data, who held the content. Now, the thing is, we do. So just again, for context, when we did our survey with our photographers, so there were approximately, say, 11,000 images on average between our members that they had online, and say approximately about 12,000 that they licensed in a year. What they actually had in their archives was, on average, about it was 440,000 images, and that's what everybody wants to get hold of. But again, it goes back to my question: what's the incentive? And so we need willing partners and an incentive, but the mechanisms are there.
Just briefly, I think that this is definitely going to happen. Technically, it hasn't happened with smaller works. Like, you can do a search of like a photographer that has been used in litigation, but it's more difficult if you're more obscure, whether or not your work wasn't training data to identify it. So just from a technical perspective, it's easy if you're Shrek or if you're Disney. it's much easier to identify your works in the outputs. But I think eventually this is where things are moving. I have a very strong suspicion, but this is a conspiracy theory, that the Ghiblification that happened was willingly participated by Studio Ghibli, because the week after Princess Mononoke was being re-released on IMAX. So I know, conspiracy theory, tinfoil hat, and I think that eventually there is going to be that happening. Lots of Sora videos about SpongeBob, none about Mickey Mouse. I'm just starting to think that there may be already agreements happening. I think Sora Cameo is going to be a big element of these people who are willingly to participate. They're going to make their likeness. You can use your likeness for creating a Sora video. We are in an attention economy. The worst thing that can happen to you is not to be recognized. So I think that's eventually going to happen. Lots and lots of people are going to be very, very willing to participate.
We've got a couple of questions.
Yeah, very briefly. The key theme in your question is that the resolution came out of litigation, and quite often litigation like this takes an area of legal uncertainty where the parties are far apart in how they view what should happen, and through a series of rulings, they're able to get closer together to make it or closer understanding of what the ground rules are going to be that make it possible to engage in then private contracts and private solutions.
We have two more questions. I think we'll take them together and see how far we get. Please.
Sorry, just almost like a point of clarification on the last one. So it's interesting, you mentioned Photoshop, but you didn't really talk about Adobe. Adobe built Firefly out of the images it had in its stock database, and then gave image rights. So the originators of a relationship around that because they had that existing relationship. They haven't been mentioned here because actually they decided early on we're going to do the right thing by our creators, and so it isn't inevitable that one has to go down a litigation route. But I think that does give the model, and has always given the model that you're referring to, that the litigation discussions will end up getting to. But it didn't have to be like this. But I appreciate that that's the way the world is.
Absolutely. Yeah.
That is a very helpful comment.
Yeah, absolutely.
We've got one more question there. So.
I have, thank you for a great presentation. All the cases here, it seems to me they're more platform related. And in terms of law, it might be easier to handle, and that's where the money are. But looking forward, AI will actually be a tool where photographers will use, and any creative person will use, and even AI will be a creator itself. How is the law seeing that scenario, which in a way, conceptually at least, doesn't look more different than a Canon or a Nikon digital camera, which has its own style, technology inside, and it's the creative mind and direction of either a human or AI who's making the creation itself?
Minutes of in sequence, please.
So very quickly, two things. Transparency, we need to know what goes into the machine, like you have with food processing. We need to know what goes into your chocolate bar in order to know it's approved and safe in that respect. Nice analogy, I think there. But the other one is about labeling. So I know Andreas was saying, billions, millions, et cetera. However, we've got to start somewhere with if we're looking at big tech as having the largest programs. Again, willing partners, potentially what they should be doing is saying, we will take responsibility for this and we will label those works so everybody is clear who, whether it's a AI generated work, especially as they become closer and closer and you start doubting what you see, because that has other implications. As we know, for a democratic society, you need to know what you believe. Even, I think recently there was a horrible photo from President Trump's opinion of a photograph taken of him on a golf course where his belly was sticking out. And he immediately said, that's generative AI. We have no idea. It could be really him. So, and this is the problem, where you start doubting what you see, then we have a challenge. So labeling is a helpful solution.
I would just comment that the transaction costs of litigation and indeed of negotiation and negotiating agreements are a key driver. Dealing with new questions means that it's very expensive to work your way through the issues, and so that's why we're at the platform level. As those transactions costs come down, we'll move to smaller and more granular agreements.
I'm an optimist. I think that the future is bright, even though it may not look that way right now. I think that after a few years of strife, we're going to sort out licensing agreements at some point. Exceptions were necessary. We're probably going to come to a status in which we can conduct businesses, but also creatives can remuneration. And if that happens, the future is bright, because imagine you creating your own series. You were very unhappy with how Game of Thrones ended. We're all unhappy how Game of Thrones ended. So you can create your own ending, licensed properly. License, you go to your computer and you press a button and you get series 8 fixed as it should have been.
Optimism is a great note to end this panel on. Please join me in thanking our speakers again.